Three recent investigations at three different Montana schools have revealed suspected inappropriate teacher-student relationships. On Monday, school leaders in Great Falls said a teacher resigned after the district found substantial credible evidence of a sexual relationship between the teacher and a 17-year-old. The Cascade County Attorney's Office identified the teacher as Levi Johnson. Also on Monday, the Ronan School District north of Missoula said a 6th grade English teacher at the middle school, who also worked as an assistant boys basketball coach at the high school, resigned before an investigation could be completed. And on January 15th, the Helena police filed a complaint accusing former Capital High School teacher Renee Carter of repeated sexual contact with a minor male not legally able to give consent between February and June of 2015. Helena Public School Superintendent Jack Copps told MTN the male was a student and that Carter resigned her position in July of 2015. The most serious allegations of teachers will be sent to the State Board of Public Education to investigate.
The board oversees teacher certification and can consider the suspension or revocation of teacher certificates. MTN's Lindsay Ford spoke to the board about the process of investigating cases like these.
The State Board of Public Education can discipline a teacher for a number of reasons, ranging from incompetency and gross neglect to conviction of certain types of crimes and immoral conduct.
Student-teacher relationship is, whether they've reached the age of legal consent or not, is still a problem.
Board Executive Director Pete Donovan says when it comes to cases of immoral conduct investigated annually,
it really varies a lot. I mean, there are some years that we have 1 or 2 cases, and there's other years where we can have 6 or 8.
Montana administrative rules say immoral conduct can mirror many state criminal statutes, but it can also be any sexual conduct or intercourse involving a minor or a person the applicant or licensee knows, reasonably should know, or should have known is a student at a public or private elementary or secondary school.
Sexual assault, sexual intercourse without consent, indecent exposure, deviant sexual conduct, offenses involving prostitution, endangering the welfare of children.
When one of the types of these cases are forwarded to the board, Assistant Attorney General Robert Stutz is contacted. It's Stutz's job to review the case, including information collected by the Office of Public Instruction and the school district where the teacher worked. If the board proceeds with the investigation, a hearing will be scheduled before the board and Superintendent of Public Instruction to consider disciplinary action.
In addition to the hearing before the board, the Superintendent of Public Instruction also has the authority to suspend a teacher's license immediately if there's a concern about public health and safety.
At the hearing, a teacher can bring in witnesses to defend themselves and have an attorney represent them. Following the hearing, the board can choose to issue a letter of reprimand, suspend or revoke the teacher's certificate.
That's why we rely on what's defined in statute and in the board's rule.
An accused teacher can also choose to voluntarily forfeit their teaching certificate. If the board chooses to discipline a teacher or the teacher forfeits their license voluntarily, that information is submitted to a national database other districts can access, should the teacher apply at another district.
It's very unfortunate when these things do happen, but I think it's important to remember that it's such a tiny percentage of educators that get involved in these kind of problems. But when it does happen, it really has a profound impact on so many people.
Lindsay Ford, MTN News, Helena.